under Articles 223, 224, and 225, we have infidelity in the custody of prisoners. Infidelity in the custody of prisoners, under Article 223, this is committed by any public officer who has in his custody a prisoner, whether a prisoner convicted by final judgment or a mere detention prisoner, and the said prisoner escapes because he connives or consents with the escape of the said prisoner. So it is infidelity in the custody of the prisoner by conniving or consenting with the escape of the prisoner. Under Article 224, that is infidelity in the custody of the prisoner by evasion through negligence. Again, a public officer is entrusted with the custody of a prisoner, whether a detention prisoner or a prisoner convicted by final judgment. And the said prisoner escapes because of the public officer's negligence. Supreme Court said, under Article 224, the negligence that is punished by law would not amount to mere laxity. The negligence that is punished by law is one amounting to deliberate non-performance of his official function. Under Article 225, we have infidelity in the custody of prisoner committed by a private individual. So under Article 225, the custodian of the prisoner is not a public officer but a private individual. And he has been entrusted with the conveyance of a prisoner or a person under arrest. Yet, the prisoner or person under arrest escapes either because the private individual custodian connives or consents, or the escape was by reason of his negligence. Whether he is a public officer or a private individual, infidelity can only be committed by the custodian of the said prisoner, by the one entrusted by the authorities to be the custodian of the said prisoner. It cannot be committed by one who is not entrusted with the custody of the said prisoner or person under arrest. X is a detention prisoner. He was charged with a crime of murder. It is a non-bailable offense. So while this case is ongoing trial, X was behind bars at the city jail. Here comes Monday. It was his day of hearing. And so, because of that, the jail guard placed handcuffs on him and brought him to the RTC, where in his case is to be heard that Monday morning. They arrived at the Hall of Justice, in particular to the RTC, around 8:15. There were already many people, but there were still few people inside the courtroom. And so the jail guard brought X, the prisoner, the detention prisoner, inside the courtroom. And then thereafter, he told him to sit in a bench. The jail guard told him, you just stay here, I will just go out. The jail guard went out, talked to his friends, police officers, other jail guards, leaving the said prisoner inside the courtroom seated on a bench, but with handcuffs. The people at about 8:25, there were already many people inside the courtroom. It was jam-packed with people. There are about 30 cases for that day. All of them are there, therefore. There were many people inside. And with these people, here comes the girlfriend of the prisoner. The girlfriend of the prisoner was able to get near the prisoner and seated very near to the said prisoner X. They talked. The courtroom was crowded. Before 8:30, they both stood up, and since this woman was holding a big bag, the woman raised the bag to cover the face of the boyfriend prisoner. And then thereafter, in this crowd of people, they were able to leave successfully the courtroom unnoticed. Thereafter, since the said jail guard was busy talking to others, and outside there was also a crowd of people, the girlfriend and the prisoner were able to leave the hall of justice. What crimes had been committed? by the said jail guard and by the girlfriend, as well as by the prisoner. The prisoner is not liable of any crime. The prisoner is a mere detention prisoner. Therefore, he is not liable for evasion of service of sentence because there is yet no sentence to evade. He is not liable of any crime. Insofar as the girlfriend is concerned, the girlfriend is liable of delivering prisoners from jail. The girlfriend assisted in the escape of the said prisoner. Hence, the said girlfriend is liable under Article 156. How about the jail guard? The jail guard is liable for infidelity in the custody of prisoners under Article 224, evasion through negligence. The said act of the said jail guard, leaving him, going outside, talking with other friends, that constitute a deliberate non-performance of his official duty as the guard of the prisoner. Supreme Court said, whenever a jail guard or jail warden would bring the said prisoner outside of the penal institution, it is his duty never to lose sight of the said prisoner. Because if he lost sight of the prisoner, he would be giving him the opportunity of escape. Here, the jail guard left him there alone inside the courtroom while he was busy talking. Therefore, such act amounted to deliberate non-performance of his official duty, the kind of negligence that is punished by law as infidelity by evasion through negligence. Articles 226, 227, and 228 is about infidelity in the custody of documents. Infidelity in the custody of documents is committed under Article 226 by removal, concealment, or destruction of the document. Here, the offender public officer is entrusted with the document by reason of the duties of his office, and he removes, conceals, and destroys this document, thereby causing damage, whether serious or not, either to the offended party or to public interest. Under Article 227, infidelity in the custody of documents is committed by officer breaking the seal. Here, the public officer is entrusted with documents and papers sealed by proper authorities, and he breaks open this seal. Damage is not required. The mere act of breaking the seal will already give rise to the crime of infidelity. Under Article 228, that is opening closed documents, the public officer is entrusted to be the custodian of this document which has been closed, of these papers, of this property which has been closed by public authority, and he opens the same or permit others to open it, although not authorized by law. No damage again is required. Therefore, the mere act of opening the closed documents will already give rise to the crime. So in case of infidelity, it is only in Article 226, removal, concealment, and destruction of documents wherein damage, whether serious or not, is required. Absent damage, infidelity in the custody of documents will not be committed under Article 226. What if this the case in a civil action, the judge has already rendered his decision. The judgment became final and executory as there was no appeal. And so the judge issued this writ of execution. It is the duty of the court sheriff to enforce the writ of execution. But a year had passed. A year had already lapsed, upon looking into the records. The court sheriff has not yet enforced the writ of execution. He disobeyed the said order of the court, and he could not give any reason for non-compliance with the order of the court, for non-performance of his duty to enforce the writ of execution against the losing party in the civil case. Can he be held liable of any crime? What crime, if any, did he commit? he is liable for open disobedience. He is liable for open disobedience because he is a judicial officer and there is a judgment order or decision issued by superior authority within his jurisdiction with all the legal formalities and without any legal excuse, without any legal ground. He openly refuses to execute the said judgment, decision, or order which he is bound to obey. Hence, he becomes liable for a criminal case, and that is open disobedience. What if the accused was charged with illegal possession of dangerous drugs? And during the trial of the case, the public prosecutor moved that a subpoena be issued to the forensic chemist at the PNP crime lab who examined the said dangerous drugs and stated in the chemistry report that indeed the things these were positive for methamphetamine hydrochloride. The said forensic chemist received the subpoena, but on the date of the hearing, the forensic chemist did not appear. There was no valid, justifiable reason given by him. And so what the fiscal did, the fiscal again moved, Your Honor, to issue another subpoena to this forensic chemist. First, to bring to court the original copy of the chemistry report. And second, to testify as to the contents of the said chemistry report. However, despite again another receipt of the said subpoena, he did not again appear in court. Is he liable of any crime aside from being cited in contempt by the court? He is liable of refusal of assistance under Article 233. Refusal of assistance is committed by any public officer who, despite demand by competent authority, shall maliciously fail to lend his cooperation towards the administration of justice, thereby causing damage, whether serious or not. Here, without the forensic chemist testifying in court that the things seized from the said accused are indeed positive for dangerous drugs, for methamphetamine hydrochloride shabu, it would be an acquittal. Therefore, the prosecution would be greatly damaged. And without the original copy of the forensic chemistry report, there is no evidence showing as to the said examination of the drugs. Therefore, the said prosecution's evidence has been greatly damaged. The said forensic chemist can be held liable for refusal of assistance. While X was walking in the middle of the night, suddenly he was grabbed and there was a sack placed inside his head. There was a sack placed on his head. And then thereafter, he was brought by these persons, 3 of them, inside the car. These 3 persons happened to be police officers. X happened to be a drug peddler who had been in hiding. And since he was seen, after hiding the police officers, there he was. They immediately placed a sack on his head and thereafter grabbed him and placed him at the police car. Even before reaching the police station, inside the police car, because the 3 police officers were so mad at him, they have a hard time looking for him. They mowed him inside the car. They boxed him. They pulled his hair, held his hair, and then banged his head repeatedly on the window of the car. As a result, the said man X suffered serious physical injuries. The said counsel of the man wanted to file cases against the 3 police officers. What case or cases may he file against the said 3 police officers? He can file serious physical injuries, and he can file also violation of RA 745, the Anti-Torture Act. But what if let us add facts. After this man walking, the police officers, realizing that he was the drug peddler whom they had been looking for, as he was an escapee, the police officer placed a sack on his head, brought him inside the car, and brought him to the precinct. In the precinct, X was investigated, and then thereafter, he was placed behind bars. Thereafter, he was again removed from the prison cell and brought to the investigation room for a further investigation. At the investigation room, he is being asked to confess who are the other drug peddlers. When he would not do it, the police officers mauled him until he became insane. What further crimes may be filed against these police officers? First, serious physical injuries under Article 263, because if by reason of the injuries inflicted, the victim becomes insane, the crime committed would be serious physical injuries. Likewise, you can file a case of violation of RA 9745, torture. And you can file also a case of violation of Article 235, maltreatment of prisoners. In the first problem, there are only two crimes which can be filed against the police officers: torture and serious physical injuries. Article 235, maltreatment of prisoners, would not yet lie against the police officers. Reason is, in the first problem, X is not yet a prisoner. He is only a person under arrest. In the second problem, X is already a prisoner. He was brought at the PNP station. He was investigated. He was incarcerated. He is already a prisoner, deemed to be an accountability of the state. So when he was tortured, the police officers also committed maltreatment of prisoners. Under Article 235, in case of maltreatment of prisoners, the offenders are public officers or employees. They have in their custody prisoner, whether detention prisoner or a prisoner convicted by final judgment. And they maltreated the said prisoner by overdoing themselves in the correction and handling of the prisoner, by inflicting penalties, punishment which are not allowed by law, by inflicting penalties allowed by law in a cruel and humiliating manner, or by maltreating prisoners in order to extort a confession or to obtain any information. Here, the three police officers maltreated him, boxed him, mauled him, in order to obtain information. Hence, they are liable for maltreatment of prisoners. And since this act of maltreatment resulted to insanity amounting to serious physical injuries, the police officers also become liable for serious physical injuries. Although the serious physical injuries is just a manifestation of these acts of maltreatment, it will constitute a separate and distinct charge. Reason is, under Article 235, the law provides that the penalty for maltreatment of prisoners is in addition to any physical injuries or damage caused. So if by reason of the said maltreatment, the victim would suffer physical injuries or damage, it will constitute a separate and distinct charge. Insofar as torture is concerned, I'm sure it has been discussed to you, under the Torture Act, Section 15, it is a separate and distinct charge because under Section 15, it is expressly provided that torture as a crime shall not absorb and shall not be absorbed by any crime which has been committed as a consequence of the commission thereof. Torture shall always be a separate and distinct crime. So in that case, 3 charges may be filed against the said police officers. What if in this case, the said police officers were convicted of torture and the President issued an amnesty proclamation? Can they avail of it? They cannot avail of it. because under Section 16, they are prohibited from availing of any special amnesty proclamation that will exempt them from criminal liability. What if this person who has been arrested happens to be a foreigner, and he was about to be extradited to a foreign country, to his own country? But our authorities have information that in the foreign country, he will be tortured. Can he be extradited? Under Section 17, no. Under Section 17, no person shall be expelled, returned, or extradited to a foreign country when there are substantial grounds to believe that he shall be subjected to torture. Under Article 236, anticipation of duties of office, this is committed by any person who is entitled to hold public office or employment, but he is required to be sworn in or to give a bond. But he performs the powers and duties of his office even without taking his oath of office and even without giving the bond required by law. In prolonging performance of duties of office, this is committed by one who is performing a public office, yet he continues to perform the powers and duties of office beyond the period required by law, regulation, and ordinance. The period has already expired, yet he still continues performing the powers and duties of his office. He is liable for prolonging performance of duties of office. A case of coup d'etat, a case of conspiracy to commit coup d'etat was filed against 3 high-ranking police officers. This case was filed before the Office of the Public Prosecutor. It was referred to Prosecutor X. And Prosecutor X called for preliminary investigation, documents, evidence were submitted, and the investigating prosecutor found probable cause. But he does not want to file a case against these 3 high-ranking public officers, 3 high-ranking military men. So what did he do? So that he would not be able to file the case, he resigned from office. And even before, the Secretary of the DOJ had already accepted his resignation, he left office, abandoning a long file of documents, a long file of cases that he has to resolve, to the detriment of public service. What crime may be filed against the said public officer, the investigating public prosecutor? He can be charged with qualified abandonment of office under Article 238. Abandonment of office is committed by any public officer who shall resign from his public position, but who shall leave already his office even if his resignation has not yet been accepted by superior authority to the detriment of public service. Public service was prejudiced. He has many cases to resolve, yet he abandons the office. If his purpose is that so that he would not be able to prosecute a person who has committed a crime under Title 1 of Book 2 or Chapter 1, Title 3 of Book 2, the penalty is qualified. In this case, he resigned from office because he doesn't want to prosecute the 3 high-ranking military officers for the crime of conspiracy to commit coup d'etat. It is under Chapter 1, Title 3 of Book 2. Therefore, the penalty is qualified, crime committed is qualified abandonment of office. Under Article 239, usurpation of legislative powers is committed by any judicial or executive officer who encroaches upon the powers of the legislature by making general rules and regulations which are beyond his powers or by attempting to repeal or amend a law. Usurpation of executive functions is committed by a judge who assumes the power of an executive officer or who obstructs the performance of functions of an executive officer. Usurpation of judicial function is committed only by a judge who assumes the power. Usurpation of judicial function is committed only by one who belongs to the executive department, and he assumes the power of a judge, or he obstructs the execution of any judgment, decision, and order of any judicial authority. There is a vacancy in this department, and there were many applicants. However, with regards to this applicant X, the said head of the department received a phone call from a friend. In fact, attached to the recommendation was this dear friend of the head of office. And based on the call, the said friend was asking the head of office to accept this applicant for the said position. And indeed, he accepted him for the said position, although the head of office knew he does not have the legal qualification therein. Is he liable of any crime? He is liable of unlawful appointments. Unlawful appointment is committed by any public officer who shall nominate or appoint any person to a public office despite knowledge that the said person lacks the legal qualification for the said position. Under Article 245, the law punishes abuses against chastity. Abuses against chastity can be committed in three ways. First, when a public officer solicits or makes immoral or indecent advances to any woman who is interested in any matter pending before him, with which he has to make a decision, or with which he has to make a report, or with which he has to consult a superior officer. Likewise, abuse against chastity is committed by a public officer or a warden who is charged with the care and custody of prisoners, and he solicits or makes immoral or indecent advances to a female prisoner. And lastly, abuse against chastity is committed by a public officer or a warden who is in charge with the care and custody of prisoners, and he solicits or makes immoral or indecent advances to the wife, daughter, sister, or any relative in the same degree of affinity of a male prisoner. In case of abuses against chastity, the act being punished is the mere act of solicitation or making indecent or immoral advances, and the offended party is always a woman. This solicitation and immoral advances, however, must be made directly with the intent to threaten the said woman such that if he would not give in, the decision would definitely be adverse. This doesn't refer to casual solicitation. This must be one made directly with the intent of threatening the woman to give in, otherwise the decision would be adverse. The jail ward, there were many prisoners. Among the prisoners in this BJMP in this city is prisoner X. She is a female prisoner. The jail warden found her beautiful. The jail warden courted her. And thereafter, she answered yes to the jail warden. So they are now boyfriend and girlfriend. The jail warden would often ask her to get out of the jail. And in the office of the jail warden, they would have sexual intercourse with the consent of the said female prisoner. Is the jail warden liable of abuses against chastity? The jail warden is liable of abuses against chastity. The said prisoner is an accountability of the state, and the jail warden has been entrusted to be the custodian of the said female prisoner. Yet he makes immoral, indecent advances to the said prisoner. It is abuses against chastity because the act of sexual intercourse was with her consent. If the said act of sexual intercourse is against the will, it is rape. In fact, it is qualified rape under Article 266-B because there was abuse of public possession. So if it was done with consent, then it is abuses against chastity. Title 8 is crimes against persons. Okay na ba? Ayaw niyo na? So, I will dismiss you already. Pagod na ata kayo. So, I will start with Title 8 tomorrow.